Thanks, Michael. Yeah, guys, hi to everyone. Good afternoon. My name is Shane Costelloe. I'm an employment lawyer with Holmes Malley Sexton. I've been with the firm just over 8 years now, and as you can imagine, we've had a very busy few weeks since the COVID crisis hit. So what I'd like to do is just give you a flavour of the issues that we've seen in the marketplace, what we've seen clients do, and what we've been advising clients on how to address these issues. So there's three main options which can be implemented now to reduce cost, and I'd like to look at these options in terms of if it's legally possible to do so, how do I affect such measures, and then what are the risks to doing these. So the best way to talk you through this would be by giving you a hypothetical example based on what we've seen recently in the last few weeks. So we've got a company who has had a very strong 2019. Q1 2020, they made a good start to the year. Obviously, the COVID crisis hits at the very end of Q1. They're looking into Q2. Turnover is immediately down 25% due to the coronavirus. You're looking ahead to Q3 and Q4. An awful lot of unknowns. The turnover could even drop to 50% of where it was, possibly even more. So companies, in order to survive, they look at their turnover, they see it's down, they know that they have to reduce costs. So what I'd like to do is set out some of the options that we've seen employers take in order to reduce their overheads. Obviously, workforce being the largest overhead for many companies. So the first option would be to apply a pay reduction. The key focus for government recently has been to maintain the employer-employee relationship. And we've seen with the COVID welfare schemes that has been the main intention of the schemes, to make sure that there is no breakage of that employment relationship. So really, it's in order to have a swift bounce back of the economy, keep the numbers of employees under the roof. And obviously, in 2019, one of the key risks or topics that employers used to come to us with was the retention of talent. How do we keep staff? They obviously want to now try and keep their best people at the moment rather than just having to lay off all staff or let them go, and avoid a temporary or permanent breaking of that employment relationship. So legally, can a pay reduction be applied? In short, without the consent of the employee, there is a risk that you'll be in breach of the Payment of Wages Act. So what we'd say is, to mitigate this risk, you should consult with your employees. Now, some employers would say, look, how can I go to someone and ask them for a pay cut? Well, if you lay out the options to your employees on the table and say, look, you either have a pay cut, or there could be potentially be some layoffs or some redundancies down the line. You know, I think it's one of the sensible decisions to be made by the employee to take the pay reduction. So the second option then, in terms of reducing cost, it has two aspects to it. It's layoff and short time. You would have heard a lot about these two topics in the last couple of weeks. So both are temporary reductions in the number of the workforce. It's a temporary breaking of that employment relationship. And I suppose to give you some better explanation of what both are. So layoff arises where an employer is temporarily unable to provide any work for the employee. So the employee does not report for work, and then the employer will not pay the employee, but only if the contract of employment allows them to not be paid for the period of layoff. Short time then is where there's a reduction in the amount of work down to less than 50% of their typical hours worked in a week, and they're also paid less than 50% of their typical weekly wage. So how do I implement a layoff or a short time? First things first, you have to give reasonable notice to staff. Reasonable notice I suppose in the current climate has come way down. Often you'd expect 3 or 4 days notice, possibly even a week. But in the recent crisis, we've seen that reasonable notice has come down as short as 24 hours. So if there's a dramatic, urgent need to reduce the numbers of staff because of the cost, the overhead, employers have in the last few weeks given just 24 hours notice for a layoff or short time. So one of the next key concerns in terms of implementing layoff and short time is the selection of particular employees. So if you have, for example, 10 general operatives who are working on a factory floor, you only need to pick 4 for layoff because that's how much the overhead reduction is required. How do I go about picking those 4 out of the 10? So really, to mitigate the risk there, you should use a selection matrix. So what a selection matrix is the table set out with headings, and the headings are basically something like qualifications, skills, contribution to the rest of the business, and each employee should then be graded under each of the headings. The result then will give you the lower scoring employees, and they're the ones who should be selected for layoff for short time. So then how does this temporary scenario come to an end? So typically after 4 weeks continuous layoff for short time, an employee is entitled to claim a redundancy from their employer. That's also 6 weeks in a 13-week period. So it's 4 continuous weeks or 6 weeks in a 13-week period. Now, in a great move for employers, the recent COVID-19 emergency legislation, which was passed by the Iraqis at the end of March, actually suspended this right. So employees can no longer claim a redundancy from their employer for this emergency period as is defined in the legislation. So that's currently up to the 31st of May. So currently you can put your staff on a layoff without any risk of them claiming redundancy. Now, it remains to be seen whether that emergency period is extended beyond the 31st of May, but as things stand, it probably looks like it does. This leads us into our third option. So that's the good old-fashioned redundancy. So everyone's probably familiar with the concept of redundancy, but just to give you the definition, so it is a permanent cessation of the role, and the employment relationship comes to an end permanently. So how do you affect the redundancy then? First, I suppose you have to consider how many employees are needed to be made redundant. What is the cost implication of that? What is the saving? These are all key decisions that need to be made in terms of demonstrating the fairness of the procedure. So secondly, then put your employees at risk of redundancy on notice that they could potentially be made redundant. That's again a key step, and it's all about that open communication channel with your employees. Number 3, select the pool of employees who are going to be possibly made redundant. So selecting the pool means, again, back to our example, you've got 10 general operatives on the factory floor. It's any employees who are potentially do similar work or comparable employees should be put together in a pool, and it's of them should be people who are selected for redundancy. So again, applying the selection criteria is by way of selection matrix. Set out your headings, grade the employees, come up with your results, and those persons are the persons selected for redundancy then. A key theme throughout the whole selection and redundancy process should be for employers to act reasonably. So that is done by way of acting by way of fair procedures. It's important to consult every step with employees, get their opinion, open up the communication channels, and have a paper trail through each decision you've made, whether that be at board level, at management level, minutes of meetings, all key steps in terms of any kind of defense of a claim that may come down the line. So what are the risks in terms of affecting a redundancy? Well, an employee could claim that it wasn't a genuine redundancy. They could claim that they were unfairly selected for redundancy. They could claim that it wasn't impersonal, which means that they were selected because of who they are rather than their role. So that's the key step in the selection matrix, that you can point back to that and say, no, this was done on an impersonal basis. The test was applied across the board to everyone in the same manner. So what can it lead to? It could lead to an unfair dismissals claim in the WRC, the Workplace Relations Commission, if someone has a year of service, or it could lead to a claim for wrongful dismissal in the High Court if someone has less than a year of service. They're quite rare. I suppose finally, one point I'd like to touch on is a kind of a logistical point, and that is the terms of managing annual leave for employees when they return to the workplace when, I suppose, the suspension of employment is over. I suppose the key test here is how do you manage when in Q3 or Q4 you have 100 staff, they all come back, they're all got annual leave. How do you have and then take that in a fashion that's not, I suppose, all taking it together? You can compel an employee to take annual leave. Now, I suppose it has to be, subject to you reconciling that with the work requirements, family responsibilities, and also the employee's right to take rest and recreation. Now, a key point here is that there should be at least 1 month in terms of notification and consultation with the employee representative or a trade union, if you have one in place, before you compel an employee to take annual leave. So that's it from an employment law point of view. Again, as Michael said, happy to take any questions at the end.